have a legal aid attorney in my custody dispute with my ex over our 11-year-old daughter. I only met her in person once in 15 months. She's never laid out a strategy for my case. My ex has been an alcoholic for all of my daughter's life, and although we live together, he never was an active participant in her upbringing because of his drinking. I understand that I'm extremely lucky to even have had a legal attorney appointed to my case. I also fully am aware that she has so many other clients just like me that she needs to attend to, and I am extremely grateful. But for the first 7 months of my case, I had no idea what was happening because she was not explaining anything to me. My ex has a paid attorney, and anytime he wants something changed that would not work in my favor, my attorney does not explain to me whether it would be helpful to my case. And in fact, anything my ex's attorney puts forward works directly against me. Yet my attorney doesn't really try to oppose it. We were supposed to go to trial this week, but it's been postponed. My ex's attorney submitted a parenting plan. The guardian ad litem submitted a parenting plan. I was never told by my legal aid attorney to work on a parenting plan or that I needed to work with her on a parenting plan. She expects me to just go along with everything my ex wants, and it does not work to my benefit at all. In fact, I would be held in contempt of court if I signed this parenting plan and failed to meet their demands. Yet, she sent a copy of it and asked me to go over it and sign it. I cannot understand how any attorney would advise their client to sign this parenting plan or not advise me against it. I've never tried to take custody away from my ex. All I've ever wanted was to protect my daughter and have him get the help he desperately needs. But apparently, even though he was arrested for assaulting me, no one seems to believe my claims or my daughter's claims. I have all sorts of proof, and there are criminal records of him being arrested for DUIs. At one point, my daughter was the subject of an Amber Alert because he never returned with her after dropping her off at an appointment. Last year, my daughter went crying, telling teachers that she was so afraid of her father and that her father was an alcoholic, so DCF was contacted. He refused to speak to DCF without his attorney. I had nothing to hide and was willing to speak to DCF, as was my daughter. I asked for all sorts of support and help. At the end of their 45-day investigation, I was sent a letter stating that their investigation was closing. My legal aid attorney refused to speak with DCF on my behalf. My ex threatened both my daughter and myself. During one visit, he was intoxicated to the point of where he thought my daughter was lying to him. So he threatened to lock her out of the house and make her sleep in the garage all night. I reported it to my attorney, and all she said to me was, "Okay, I see." She never advised me that we should file a motion for my ex to not have shared custody until he gets help for his drinking. She's never advised me on how to handle anything that my ex has done to me or to my daughter. I understand that you don't get the same representation from a legal aid attorney that you would get from an attorney you're paying for, but I would imagine that if they take your case, they need to represent you to the best of their ability, and that all attorneys, whether paid or legal aid, have a responsibility to their clients. But I can't find an answer to this question anywhere. I feel as though anyone I've asked feels that I'm ungrateful, and so many people wish they had a legal aid attorney representing them, but they won't take their case, and that I'm expecting way too much. But all I'm asking for is to have things explained to me and for my attorney to help me protect my daughter when my ex is intoxicated and abusive to my daughter. All I'm asking for is for someone to explain to me, does a legal aid attorney have a legal obligation to represent their clients in the state of Connecticut in the same way a paid attorney would have to represent their client? I understand that they have so many clients that they have to represent, but if they take your case, should you expect them to represent you and advise you in what's in your best interest so you get the best outcome possible? Please, I cannot find anyone or any articles explaining any of those, and I'm scared of losing custody of my daughter. I have been the sole caregiver too, since the day she was born. Thank you. This case came from the Ask Justice column, and in this video, we'll explore the potential legal rights and actions that this Ask Justice user has. My name is Diana, I'm an attorney, and let's get into it. Going forward, let's call the Ask Justice user Jane. That said, based on what Jane wrote, there are a couple of rules that come to mind that the legal aid attorney may be violating. However, we'll know for sure after we analyze those rules. These rules are the Connecticut Professional Rules of Conduct, Rules 1.4, 1.3, 1.2, and 1.1. I'll begin with Rule 1.4. Rule 1.4 is about how attorneys should communicate with their clients, and it says 6 main things. 1, that a lawyer should promptly tell their client about something when the client would need to give the lawyer their informed consent about something. Informed consent means that the lawyer explained the matter to the client really well so that the client can make a decision knowing all the consequences and advantages of the outcome of the decision. 2, Rule 1.4 says that a lawyer should reasonably consult with their client about how the lawyer is going to go about getting what the client wants. 3, that a lawyer should keep up to date on the case and know what's going on. 4, that a lawyer should promptly respond to clients' reasonable requests for information. 5, that a lawyer should tell the client about the limits of the lawyer's representation when the lawyer knows that they can't give the client what they want because it's against the rules of the legal profession. And 6, that a lawyer should explain the case to their client so that the client understands what's happening and can make an informed decision. Jane said that she only met her lawyer in person once in 15 months and that her lawyer never laid out a strategy for her case. This likely goes against Rule 1.4 because lawyers have a duty to consult with their clients about the case. Jane also said that she had no idea what was happening for the first 7 months of her case because her lawyer wasn't explaining anything to her, and that she was never told by her attorney to work on a parenting plan or that she needed to work with her attorney on a parenting plan. This also likely goes against Rule 1.4 because a lawyer has a duty to explain the case to their client so that the client understands what's happening and can make informed decisions, and because a lawyer has a duty to promptly respond to clients' reasonable requests for information. So if Jane's allegations are true, the lawyer is likely violating Rule 1.4. Next, we'll analyze whether the lawyer violated Rule 1.3 of the Connecticut Rules of Professional Conduct, which is about how carefully and diligently a lawyer should handle her case. Rule 1.3 says that a lawyer should act with reasonable diligence and promptness when representing a client. This means that a lawyer should represent their client well and that they need to manage their workload to make sure that each case receives the attention it deserves. Jane said that anything her ex's attorney puts forward works directly against her, and yet her attorney doesn't try to oppose it. Jane also said that the parenting plan is practically so bad that she doesn't understand why her attorney didn't advise her against it. If this is true, her attorney's actions likely go against Rule 1.3 because it appears as though her attorney isn't being diligent with Jane's case when it comes to advising Jane and responding to court documents. Next, we'll analyze whether the lawyer violated Rule 1.2, which is about how attorneys and clients should work together on the case. Rule 1.2 says that a lawyer should respect and follow their client's decisions regarding the ultimate goals of the case. For example, whether the goal is to obtain full custody or get a divorce. The rule also says that a lawyer should consult with their client about how the lawyer will go about achieving that ultimate goal. For example, by filing certain motions or recommending mediations. Jane said that her lawyer expects her to just go along with everything that her ex wants, but that it doesn't work to her benefit at all. This doesn't sound like the attorney is working with Jane to achieve the goals of the case, nor consulting with Jane to let her know how the attorney will help her. So if Jane's allegations are true, the lawyer is likely violating Rule 1.2 as well. Next, we'll analyze whether the lawyer violated Rule 1.1, which is about a lawyer's competence. Rule 1.1 says that lawyers should provide competent representation, which requires that a lawyer have legal knowledge, skill, thoroughness, and the preparation that's necessary for the representation. Again, Jane said that she only met with her attorney once in person in nearly a year and a half, and that her attorney never laid out a strategy for her case. This does not sound like the attorney is being thorough, nor is prepared for Jane's case. So if Jane's allegations are true, the lawyer is likely violating Rule 1.1 also. Finally, as for Jane's main question, whether a legal aid attorney has a legal obligation to represent their client in the same way that a paid attorney would have an obligation to represent their client, the answer is yes. Legal aid attorneys and attorneys who are paid by their client are all held accountable under the same rules of the legal profession. Just because you have a pro bono attorney doesn't mean that your case should be neglected. In fact, if attorneys are too busy, they shouldn't accept additional cases under the rules of the legal profession. I hope that Jane now knows that even though she's getting legal services for free, her case still deserves attention and care. As you noticed, for the purpose of this video, we analyzed this case based on Connecticut rules. However, if you're in a different state, some of the processes may be similar, so I hope that you still got a general sense of what you could do if you find yourself in a similar position as Jane. You can also always ask us anonymously for your state-specific resources if they're not already posted on our website. And as you know, it's best to always seek advice from a licensed legal professional in your state. I hope that you enjoyed watching this video, and I look forward to bringing you more valuable legal insights in the future.